Hello and welcome. My name is John Kelly and I'm joined by Jackie Milne. We both work with JISC Legal, which is a JISC Advanced service. This question and answer session is about the recording of lectures by institutions. Recorded lectures can be useful learning resources and can allow students and learners to access content on demand. Jackie has produced a significant guidance paper just recently on recording lectures, and I wanted to ask her about the legal issues when an institution decides that it will introduce recording lectures live. So Jackie, by way of an overview, what would you say are the most important things for institutions to be aware of when recording lectures?
Well, I think there are three main areas that institutions should be aware of. The lectures and the recordings themselves are likely to include content that's been created by a variety of parties, such as the lecturer, the tutor, the learner potentially, and by another party external to the college or the university. So the first and probably most significant issue will be copyright, for the institution to ensure that that content does not cause any infringement and potential liability for them. In recording individuals as part of the lecture, data protection is likely to be relevant. So you'd be looking there for some form of consent that all parties agreed to the recording to take place. The third area relates to performance rights. Under the law, if the institution records and makes available a performance, then they have to have the consent of the performers to do that. Now, it's not strictly clear whether a lecture would constitute a performance, but I think it's certainly arguably so. And to avoid any risk of infringement, the institution would be required to obtain the consent of performers such as the lecturer, and that might be a student performing their own work, for example. So I think those are the main areas that institutions really need to bear in mind from the start.
Right, so if I'm a lecturer and I've built up my own lecture and teaching notes and overheads and PowerPoints over the years, does my institution own all of these?
That's a good question, and one that we're asked quite often. In most cases, if you have an employee, i.e. a lecturer, who's producing materials that relate to their job, it's part of their job description, then the copyright will firstly vest in the institution as the employer. Now, that can also be subject to an agreement that says otherwise, of course, and so it's important for institutions to be aware of whether these agreements are in place and what they contain.
And what about if it's a guest lecturer?
Yeah, a guest lecturer is in a different position. Copyright will usually rest with the author in that circumstance, and that means the institution would need to think about how they can use that material. So they might, for example, ask that the guest speaker assigns or transfers copyright to the institution, which means they can use it freely, but more likely the institution will have a license between themselves and the guest speaker that will allow them then to reuse the material. And obviously, if that's wide, that's more beneficial to the institution. But again, it's important to clarify that issue and put the appropriate agreements in place.
What about content that's already being used by lecturers? Can that be recorded? Let's say, for example, there's a YouTube clip in a lecture. Can that be used?
Well, the situation is different whether you're using materials in a live lecture or whether you're recording those materials, because the recording is likely to be regarded as further copying. There are exceptions, obviously, in copyright law that will allow lecturers to play or perform a YouTube non-infringing video, for example, to learners within the institution. But in making that recording, those exceptions for the most part are unlikely to apply. So really what institutions need to do is to encourage their tutors, their lecturers to use openly licensed resources, such as in the example you gave, if it's a YouTube clip that has a liberal Creative Commons license, for example, then that's obviously, that would be able to be recorded and reused.
So you find that out by going to the YouTube clip and find out what, what its status is?
Yes, it's not always as straightforward as that, but usually there will be a license attached to the resource. And if there isn't, then you'd need to go through a process to trace that.
What about, say, the institution has already had old recordings or lectures of old from before? What can be done with these?
Maybe tape recordings and so on, yeah. Well, I think we're back to the kind of same scenario, making sure that the content of those recordings doesn't infringe rights of others. And also, I mean, institutions will also have to think about whether content is accurate and up to date. So these are issues that they would need to, you know, check and make sure were in place.
All right, well, what's the real likelihood of institutions being pursued for infringement? Like, this is, after all, this is educational, non-commercial use. Do the education exceptions allow fair use for teaching and learning?
Yes, another good question. As I mentioned earlier, the education exceptions that you've referred to, for the most part, will not apply where you're then making a further copy. We deal with that in a bit more detail within the paper, the guidance paper.
Right.
Fair use is a US term. We don't have that in UK law. What we have is called fair dealing, and that's a bit more restrictive. As for the fact that institutions are educational, they're not using it for commercial purposes, although that might be relevant in an award of damages, for example, that's not going to be a defence to infringement. We do know of cases where institutions have been pursued aggressively by commercial organisations, and as a result of that have had to pay fairly substantial fees. So it's not really a position that institutions want to find themselves in. Obviously, it's up to the copyright holder as to what action is then taken, whether that's a court action, which is unlikely because of cost, whether it's a settlement and an agreement of a fee, which is more likely, or it might be the copyright holder just wants an apology and the content to be removed. So you know, it will depend on the circumstances and the situation, but it is worth considering that if you are using materials for non-commercial educational use, you're attributing the author in an appropriate way, and you're showing the material in a positive light, then it's quite likely that they will agree to that and they will give you permission for doing that.
I know that some institutions consider that if they record lectures, then this is to be considered a sort of a reasonable adjustment for those with disabilities. Is that okay?
Well, making lectures accessible will benefit all learners, not just those with disabilities. We know that institutions have a legal duty to make reasonable adjustments, but it should also be remembered that, you know, if that involves recording a lecture and that includes third-party works, then the institution may require a licence to do that, and there may be a cost involved with that.
Okay. Some learners won't be that keen to be on camera in the first place. What's the best way to handle that? Yeah, well, probably the fairest way of handling that would be to, obviously the student comes along to the lecture, they shouldn't be excluded in any way, so they come along to the lecture, that everyone knows that a recording is taking place. There's perhaps an announcement by the tutor or the lecturer, and then provide, you know, perhaps the institution could provide an area of the classroom or the theatre that's not actually within the capture of the camera, so that they can attend the lecture, they don't miss out in any way, but they're not part of the recording necessarily. All right, to sum up then, what would you say?
Well, to sum up, the legal issues are significant, they are important, but they are manageable. Institutions need to be aware of what the issues are. They need to decide what their approach is going to be. They need to put processes, procedures in place. But I would add also that it's important to consult and discuss with your staff very early on in the process. And in that way, you can perhaps ensure that you have buy-in to the processes, and that you can ensure that there's consistent good practice being disseminated throughout the college or the university.
Well, thanks very much for all of that, Jackie. There's quite a lot to be considered there. Where can lecturers, institutions and others find more information on all of this?
Yes, we've already shown the paper. You can download that from the website. There's a lot more detail within that over and above this short kind of Q&A session. We also have a model consent form and a flow chart which should simplify the legal issues somewhat. And of course here at JISC Legal we have an inquiry service. So if you're a member of staff in further or higher education, we're always very happy to hear from you, whether that's to ask us a question, provide a comment or feedback. So please do get in touch with us.
This question and answer session is part of the work that JISC Legal does to ensure that legal issues are not a barrier to the adoption and use of new technologies in FE and HE. You can find a lot more resources on our website at www.jisclegal.ac.uk.